the witness's testimony. On that basis, you were requested to allow the witness's evidence, and you did so. Since then, Advocate Ngolwana, on behalf of Ms. Jiba, has approached the Commission and made certain requests of the Commission, in essence that any evidence concerning Ms. Jiba be excluded pending the issue of a notice to allow Ms. Jiba to consider her position and take legal advice. Now, Chair, the purpose of the rule, certainly as we understand it, or at least the principal purpose of the rule, is to give an implicated person an opportunity to place a version before the Commission and to make application to cross-examine, in other words, to contest the evidence given by a witness. And in any approach that you will be requested to make, that principle should remain sacrosanct. There is another potential purpose of the rule, and that is that if there's any prospect of unlawful, and I stress unlawful as opposed to inadmissible evidence being given, perhaps of a confidential nature or of a top secret nature, then that implicated person would have an opportunity to deal with it. I do not believe we are dealing with that category of issue in this matter, certainly not in the evidence that the witness intends to give. So that is the principal purpose of the rule, to allow a version to be put and to allow cross-examination to take place, and it should be respected at all times. There can be no doubt about that. The rule may be departed from in appropriate circumstances, and our submission is such circumstances existed this morning, and you, Chair, accepted that. There are two principles embedded in the rules of fairness with which this Commission is obviously bound, and in the rules which give expression to those principles of fairness. The one is that no party may, because that party, implicated or otherwise, disagrees with the evidence that a person is going to give and who's received notice of that evidence, hold a trial or a contest outside the Commission's proceedings and say, you can't lead that evidence because it's wrong, or I disagree with it, or because it's false. The proper place for that contest to take place is in this forum, in public, and indeed that is what the law requires of this Commission, to take place in public. So a witness gives evidence, that evidence is contested after that witness had given evidence. There can't be a trial outside which would influence that witness's evidence. That's the first principle. The second principle is that, and it's also sacrosanct, is that any implicated person must be given a full and fair opportunity to contest the evidence of a witness and to cross-examine, subject to the rules and the discretion that you have embedded in those rules, Chair. So those are the two sacrosanct principles. The question is, can they be met in this case? If there are circumstances which indicate that the evidence that this witness is about to give is somehow unlawful or cannot be lawfully put before a commission, that is one set of issues. I don't believe those exist here. If, however, it is merely a matter of managing a fair opportunity to respond, either by way of putting up a version or by way of allowing cross-examination, then that can be managed in any order that you might make, Chair, and the rules provide expressly for such a circumstance. I think that's Rule 3.6. There are two options then, having considered the position that I would suggest require consideration. The one is to allow the evidence, but to exclude any reference to any implicated party, because of course all implicated parties must be treated in the same manner, not only Ms. Jiba. To allow that evidence to be given without reference to any implicated party, and then to recall the witness at a later stage once notice has been given. That's the one option. May not be entirely practical. It is the cautious option. The second option is to allow the witness to testify, subject to appropriate arrangements being made on representations by Mr. Ngolwana, either now or at a later stage, to ensure that there is a full opportunity to place a version before you and to cross-examine in due course. The tape that we mentioned earlier may possibly fall into the category of that evidence that may not be led at all, and perhaps representation should be allowed on that before the tape is played. That concession we're happy to make, but otherwise, Chair, the stark choice and the approach to adopt is left with you.
Well, I said in the morning when you mentioned that Mr. Nxasana was called or pursuant to my directions, one of the things I said was that I wanted to hear his evidence in regard to his departure from the NPA, and I said, of course, then his tenure at the NPA, because he, having been National Director of Public Prosecutions at a certain stage, and there being suggestions and allegations and some evidence that there may have been interference with the NPA, and that some people in the NPA may have used their powers to charge and not to charge certain people in an unlawful way, or they may not have been motivated by proper reasons. It would be important to hear his evidence. So, one, I confirm that Mr. Nxasana was called pursuant to my direction. That's the first point. Second point, you did raise in the morning the issue that Rule 33 notices were not given in advance, were not sent out in advance, because the legal team only got a signed statement of the witness yesterday or last evening. I was concerned about that, but I indicated that in terms of my focus, it was I expected the witness to deal with largely matters that have been the subject of judgments and some litigation that would be that would have been in the courts. But of course, when a witness gives evidence, he gets asked questions and he gives evidence and he may elaborate and so on. So, and I was prepared to let him continue. And in doing so, the provisions of Rule 3 of the rules of the Commission make they provide that where a party an implicated person believes that he has not been given enough notice, that party may approach the Commission for such order as may in effect give redress to the situation. Of course, this is a situation where the notices were not given in advance at all. No, that's important to look at. I think what should happen is I should allow Mr. Ngolwana to say something if he wishes to say something. He represents Ms. Jiba, and then we take it from there. But it may well be that where notice has not been given at all, it may be that that must be looked at carefully, as opposed to where notice was given but there's a complaint that it's inadequate. The notice given is inadequate. Or, so maybe subject to whatever you might wish to say, I would like to hear what Mr. Ngalwana has to say, but it may be that we should see what can be done. The idea is always to try and be as fair as possible to everybody, but taking into account practicalities that we have to deal with. Mr. Ngalwana.
Thank you, Deputy Chief Justice. Thank you for the indulgence. Of the two options, or perhaps should I confirm that I stand here on the instructions of Majavu Incorporated for Ms. Jiba.
Yes.
None of the legal members of the legal team are in Johannesburg, so I was the only one who's here, so I've been asked to make these representations. Of the two proposals made by the evidence leader, I haven't taken instructions, but I would imagine the one that would endear itself to Ms. Jiba and the legal team might be the first one, which is to allow the witness to testify further, because he's quite right, we can't stop the witness from giving evidence in the public domain, but then not to give evidence that would implicate Ms. Jiba and the other persons who are not represented by me.
Yes.
Now, Mr. Pretorius referred to what he terms the principle of Rule 3.3. Just briefly, I wish to deal with this. Can I take us to Rule 3.3 itself? And with your indulgence, CJ, I just want to briefly read it, because it's important to understand the text of the rule so that one can appreciate the textual context and the principle that lies behind it.
Yes.
It reads as follows. If the Commission's legal team intends to present to the Commission a witness whose evidence implicates or may implicate another person, it must, through the Secretary of the Commission, notify that person, the implicated person, in writing within a reasonable time before the witness gives evidence. I stress on the word before the witness. 3.3.1. So it must be given reasonable time before the witness gives evidence that he or she, these are the things about which notice has to be given to the implicated person, that he or she is or may be implicated by the witness's evidence. I understand that the evidence leading team only learned last night about the content of Mr. Nxasana's evidence, and so there would not have been an opportunity to give prior notice. 2, in what way he or she is or may be implicated, and furnish him him or her, with the witness's statement or relevant portions of the statement. 3, of the date when and the venue when the witness will give evidence. 4, that he or she may attend the hearing at which the witness gives evidence. 5, that he or she may be assisted by legal representative when the witness gives evidence. 6, that if he or she wishes to give evidence himself or herself, to call any witness to give evidence on his or her behalf, or to cross-examine the witness, then he or she must, within 2 weeks from the date of notice, apply in writing to the Commission for leave to do so, and that the chairperson will decide the application. 3.4 then says, an application in terms of Rule 3.3.6 must be submitted in writing to the Secretary of the Commission within 14 calendar days from the date of the notice referred to in Rule 3.3. The application must be accompanied by a statement from the implicated person responding to the witness's statement insofar as it implicates him or her. The statement must make it clear what parts of the witness's statement are disputed or denied, and the grounds upon which those parts are disputed or denied. And lastly, this is the last part I'm going to read, if an implicated person believes, and this is the part that I understand the DCJ was dealing with, if an implicated person believes that the Commission's legal team did not give him or her notice referred to in Rule 3.3 within a reasonable time before the witness could or was to give evidence, and that this may be prejudicial to him or her, he or she may apply, that is the implicated person, may apply to the Commission for such order as will ensure that he or she is not seriously prejudiced. That's why I'm here. There is nothing in Rule 3.5 that says that application must be in writing. And of course, since the legal team...
Well, you might wish to look towards the end of the rules for
Yes.
something that might say any application provided here needs to be a substantive application. I seem to
Yes.
think there is something along those lines, but
Yes.
anyway.
I appreciate that,
Yeah.
DCJ, but given the
Yes.
circumstances,
Yeah.
when one learns of
Yes.
evidence that might implicate a
Yeah.
person on the morning, effectively 5 minutes
Yes.
before the beginning,
Yes.
it's impossible that one would be able to put that in writing.
Yeah.
Now, the rule as I've read it talks about the statement of the witness likely to implicate the implicated person. Notice of the statement being given. It doesn't say notice of evidence being given. So it is to the statement that the implicated person is to respond. The reason I make this submission is this. Mr. Pretorius says in his second option that Mr. Nxasana may testify on all and sundry, including evidence, as I understand it, evidence that may implicate Ms. Jiba, subject to Ms. Jiba being given an opportunity in due course to come and place her own version before the Commission. Now, the Rule 3.3 to 3.5, as I've read it, doesn't seem to me to countenance such a proposition because it deals with statement. It doesn't deal with evidence. And if a witness is permitted to make or to give evidence that implicates a witness who hasn't been given notice and then is given an opportunity to come and place evidence later, the damage is long done because, as we all know, we are all members of society. We watch television, we read newspapers. Whatever is said by a witness, especially in this commission, at least it has been my observation, is any allegation, not even proven evidence, any allegation that is made against a person is taken by society to be the truth before it's even tested. And so by the time, in due course, Ms. Jiba comes to test that evidence, it's too late. Now, Chairperson, there is a fear that the legal team and Ms. Jiba has. And I appreciate your explanation of how Mr. Nxasana came to testify today. It is the timing of the evidence. The concern is that the President has relieved Ms. Jiba of her duties as the Deputy National Director of Public Prosecutions. But that decision still needs to be considered by the National Assembly. Now, there's a debate about whether the National Assembly needs to approve the President's decision or it's simply a rubber stamp. I haven't studied that, but it certainly has to be considered by the National Assembly. And so the fear is that any evidence that implicates Ms. Jiba without her having been given prior notice may color those considerations by members of the National Assembly. We don't know yet when the National Assembly will consider this. We have the State of the Nation address coming up in a couple of days' time. I don't imagine that is a platform for this sort of thing to happen. So, in short, Deputy Chief Justice, without having taken instructions, but I imagine this might be a practical way to go about it. The first option that Mr. Pretorius suggested, which is to lead Mr. Nxasana in evidence, except the evidence that would implicate people who have not been given notice. There was one last thing. Which I forget now. Well, if I forget, it couldn't have been that important.
Yeah.
TCJ, unless there are
Yes.
other questions that you want to put to me, those would be my submissions for now.
Yes, no, I just want to confirm again that as far as I know, the only reason Mr. Nxasana is here is because I gave directions that a number of witnesses be called, and he was among those. And it was not the first time that I said she should be called. Already last year, I had said he should be called. And I think some attempts were made, but it didn't happen.
Yes.
Early this year, I had said he should be called. And some attempts may have been made and it didn't succeed.
Yes.
So he might have had nothing to do with
Yes.
him being here and Ms. Jiba maybe, or his evidence being at a particular time. Nor would the legal team really of the commission have had anything to do with that. And from my side, as I indicated earlier on, and you were not here, with all the allegations about what has been happening at the NPA, this commission can't finish its work in regard to the law enforcement agencies, what's been happening, without hearing evidence of somebody like Mr. Nxasana.
Yes.
So I just want to clarify
Yes,
that.
no. Thank you, DCJ. Deputy Chief Justice, that thought has come back to me while you were addressing
Yes,
it.
yes.
It is the extent of the evidence that Mr. Nxasana may be led on by Mr. Pretorius. There has been a suggestion that if the evidence covers matters that are already in the public domain, or matters that have already been dealt with in
judgments.
affidavits and in judgments,
Yeah,
that Ms. Jiba would have had an opportunity to deal with those in any event, so there should be no impediment to Mr. Nxasana testifying to those issues. The difficulty with that, ordinarily, I would have no difficulty with it. But the difficulty in these circumstances is I don't know what evidence he's going to testify to
yes,
that is already in the public domain. That's
Yes.
the one thing. And so
yes,
one needs to perform this exercise of looking at what is already in the public domain to which Mr. Nxasana would testify
Yes.
to, and so one would not raise any objection.
yeah,
So the exercise that needs to be performed is look at what is in the public domain and what is new.
yes.
Standing here now before you, I don't know what is new, what is in the public
Yes.
domain. And
Yes.
so it seems to
Yes.
me reasonable and practical to allow the legal team to perform that exercise.
Yeah, yeah.
Had we known that Mr. Nxasana is going to be testifying today,
Yes,
we
yes.
probably would have performed that exercise
Yes,
already. We can't
yes.
now be
Yes,
penalized
yes,
and be expected to sit in a commission. I could sit on a watching brief
yes,
to listen to what is being led to, but since I don't know what's already in the public domain, I can't stand up and object or tug my learned friend by the sleeve of his jacket and say, well, hang on a second,
yes,
that is not in the public domain because I don't know.
yes,
And
yes.
so, Deputy Chief Justice, I would request that the first option that Mr. Pretorius suggested, which is, and I would add this, that evidence should subtract any evidence that implicates Mr. Nxasana, whether it's in the public domain
Ms.
or
Jiba.
not. Did I say?
You say Mr. Nxasana.
Oh, I'm sorry. Mr. Nxasana doesn't seem to be implicate. Any evidence that implicates Ms. Jiba should be held back. I'm not saying it should be excised or not dealt with. It should be held back. The opportunity for dealing with such evidence at this forum will come. It may be next week. I don't know what the schedule of the commission is. It may be next week. It may be in 2 weeks' time.
Yes,
By
yes.
that time, the legal team for Ms. Jiba would have performed all these exercises, and therefore the matter can continue without any discomfort from Ms. Jiba's team.
As we speak, what I am inclined to allow is Mr. Pretoria's first option, which you have no problem with. But when I say that, I am inclined to say there should be no problem if the evidence includes evidence or includes matters that have been dealt with in court judgments or affidavits filed in court on matters that are in the public domain already, in respect of which, whether it's Ms. Jiba or the former president or Mr. Mxolisi, where they would have had a chance to deal with. In regard to the point you make, namely that as you stand there, you don't know what those may be because you haven't had a chance to have a look. I'm wondering whether there would be no problem if we proceed on the basis that Mr. Pretorius would be cautious to lead the witness in regard to matters that fall within that. And you might not be aware of it as long as it can be shown that they are matters that are dealt with in judgments or in affidavits that have been in court and so on. And then and therefore that for now there shouldn't be any new matters dealt with that implicate persons that have not been covered in that way, but that when Mr. Nxasana comes back, everybody who is implicated has had a chance. Then he can cover all new matters. That's the inclination I have. What do you say about that?
Yes, Deputy Chief Justice, far be it from me to doubt my learned friend Mr. Pretorius's intentions or integrity. I even hesitate to bring in the word integrity. I'm quite confident that he will do precisely that and steer off away from new matters.
Yes.
Might it not be a sort of belt and braces job to request Mr. Pretorius to, when he puts such questions to Mr. Nxasana that have previously been, or dealing with matters that have previously have risen on affidavit or in judgments, perhaps prefix the question. I know it may be a tough ask, but, because maybe he didn't prepare it that way.
Yes.
To prefix the question with Mr. Nxasana, in the matter of so-and-so in the judgment, without citing a particular paragraph, this matter was dealt with. Can I ask you this question, then ask him, or in a particular affidavit, in a matter, this was dealt with, so that when I keep my note, I know exactly which judgment to go to satisfy myself and the legal team that that matter had indeed been dealt with previously and that it's not new.
I think what would be important is that the witness evidence is limited to those parameters. Whether Mr. Pretorius refers to which affidavit in which matter and so on and so on, if he can, I'm sure there's no problem, but if he's not able to, as long as in due course you can be informed to say that related to that, that related to that, so as long as that can be done, it should be fine.
No, I'm happy with that.
You would be happy with that? Okay, all right. I think we'll proceed. Mr. Pretorius?
Thank you.
Thank you, Mr. Ngalana. Mr. Pretorius, what do you
Chair, just
say? That's the inclination I have, but you haven't had a chance.
just a little more briefly than what has occurred so far. The first thing is you will make an order, I will abide by that order. I cannot suggestions. Yes, let me do that then. Firstly, it's important to place on record this issue of timing. There is a suggestion that the witness's evidence has been timed intentionally or unintentionally. I don't know how you time evidence unintentionally in order to prejudice Ms. Jiba. Let me state quite clearly that is not the case. I can give you, Chair, an assurance, and as you know, Chair, it was at your direction.
Well, I've made that quite clear,
that this happened. In any event, the timing was not a choice of the witness.
Yes.
Timing was imposed on the witness by the Commission at your request. He had nothing to do with it at all. The third is that in any event, the consequences of evidence being led under oath or under affirmation at a public inquiry of this nature would inevitably affect other issues in other jurisdictions, and that must be so. Those consequences can never be an excuse or a ground for not leading evidence that we are obliged to lead here by virtue of statute. But that's not an issue that we need to do any more than note for the present.
Yes, yes.
The second point that we would like to emphasize as a legal team, Chair, is the very nature of a public inquiry. It involves encouraging witnesses to come forward, to give evidence within its terms of reference. It is inevitable. The statute contemplates it, the terms of reference contemplate it, the regulations contemplate it, the rules contemplate it, that persons will be implicated by evidence adverse to that person's interests. It's the very stuff of this inquiry that evidence would be led implicating other persons, in many cases negatively or adversely. That principle can't be undermined by any order that you would make, Chair, or anything that the legal team could agree to, provided witnesses are treated fairly and those rules are there for that purpose. So,
Yes.
Chair, all we submit is that the principle must remain sacrosanct, that witnesses must not be prevented from giving such evidence as they're entitled to give.
Yes,
without
but
fear,
remember,
prejudice, or
Mr. Ngalwana also made it clear that they are not seeking to prevent the leading of evidence.
Well,
it's just the timing.
No, that's clear, and in the
Yeah.
solution that we will reach,
Yes.
that principle will be met. But the public out there is listening to this argument.
Yes.
And it can never be the case that the public should be discouraged from coming forward to give their evidence in fear that prior to their giving evidence, they will somehow come under some sort of judicial or other attack, and somehow their evidence will be influenced in that way. So the principle that must remain sacrosanct, we submit, is that witnesses must believe that they are free to come here and give evidence, whatever its consequences, and however damaging it may be to other people. And I believe in the solution we've reached that is sacrosanct. It's subject only to one duty, and that is the duty of the Commission to act fairly, and that we're trying to do in that case. The last point that I'd like to make, Chair, is that I will obviously abide by your ruling, but the intention is not to deal with anything beyond the interactions that gave rise to the many court applications and decisions of the court. And in fact, insofar as a judgment deals with a particular issue, one may assume that that is in the public domain. It's a matter very clear. Thank you, Chair.
I just want to emphasize again that the Commission seeks to strike a balance between various or among various interests, and one of these is that it seeks to ensure fairness to all parties, including implicated persons, I have made it clear over the past year or so, both in media briefings and in this venue, that implicated persons will be dealt with fairly as well. They must be dealt with fairly, and that nobody will have findings made against them just because of what the media may be saying about them or against them. Any findings that will be made on the basis of evidence led in the Commission. And throughout, we continue to try and be fair to everybody. I thought I must just emphasize that. And again, to the extent that there may have been any thinking that Mr. Nxasana's being here is timed by anybody to coincide with anything, again, I indicate that he was called because I gave directions that he and certain other witnesses whom we are not mentioning now be called. And I've been told that some of them are not available, so they may have to be called later. So we'll continue to have situations where a person who is implicated or not implicated, but a person who, in the view of the Commission, has knowledge or information that may be helpful in the inquiry of the Commission, may be called to come and give evidence. So it's not the last time that a person is called to give evidence because the chairperson so directs. But fairness to all implicated persons is very important. But as I say, there is fairness that must be taken into account together with all practicalities and constraints that the Commission has, within which the Commission must operate. So these are just the remarks that I consider important to make. With regard to how we proceed, I confirm that we are going to follow the option one that Mr. Pretorius mentioned, with which Mr. Ngalwana doesn't have a problem, subject to the remarks he made, and on the understanding that I believe we, all three of us, have achieved here in this open hearing, in terms of also matters that may be in the public domain by way of court judgments and affidavits filed in court. And Mr. Pretorius, in leading the evidence of the witness, will bear that in mind as he leads the evidence of the witness. Of particular importance in this case is that the legal team was not able to give notice even to say Mr. Nxasana will be giving evidence. Sometimes there may be a situation where notice was given in terms of Rule 3.3 of the Rules of the Commission, but the 14 days did not lapse. That might fall under different considerations. So Mr. Nxasana will have to come back on a later date to finalize his evidence that would cover any matters that will fall outside of the parameters that I've indicated as discussed here at the open hearing with Mr. Pretorius and Mr. Ngalwana. That is how we are going to proceed.
Thank you, Chair.
I would like to take a 5 minutes adjournment and then we'll continue. We'll just take a 5 minutes adjournment. We adjourn. You may proceed, Mr. Pretorius.
Chair, just a housekeeping matter. I've decided to deal with something that I had intended to deal with at the conclusion of the witness's evidence, and that's the Constitutional Court judgment.
Yes.
One can safely assume that matters commented on by the Constitutional Court and contained in the judgment particularly are matters in the public domain. They do not in any event implicate Ms. Jiba or any other individual apart from the former president in any sense at all, and those are merely comments.
Well, you are of course not suggesting that what you mean is whatever it is you are going to refer to is something that has been said by the court and is in the public domain.
And all parties concerned have had an opportunity to present their versions, argue fully, and the result of all that process in the highest court is what I'm going to refer to.
Okay.
Chair, in addition to that, Mr. Nxasana himself raises a concern that he's here at some personal cost, and at the request of the Commission, he didn't volunteer to come forward.
Yes.
And given that his evidence may now stretch over to another day, it's a matter of some concern, and I would just wish to place that on record. It was communicated to me during the recent short adjournment.
Yes, maybe before you proceed, let me talk to him. Mr. Nxasana, it appears that it's inevitable that you may have to come back. Now, Mr. Pretorius tells me that you are concerned about that. It doesn't mean you'll come back tomorrow, so you may have intended to spend only today at the Commission. But in terms of when you would come back, your availability would be looked at as well. Does your concern remain notwithstanding?
Yes, Chair, it remains, Chair, notwithstanding.
Yes.
Chair, as I have explained, that I run a practice.
Yes.
And unfortunately, I'm a sole proprietor of my practice.
Yes, yes.
My practice is suffering.
Yes.
As I am here.
Yes.
In fact, I've been here not only today.
Yes.
2 days.
Yes.
Already.
Including yesterday.
Including yesterday.
Yes.
Yes.
No,
And I see that it's inevitable and it's anticipated that I'll have to come back.
Yes. No, I think it's unfortunate that this is the situation, and I appreciate what you are talking about when you are a sole practitioner in a legal firm. When you are not there, you are not earning income, and there are people you have to pay at the end of the month. There are bills to be paid. But the legal team may have to have a look. I mean, if somebody goes to give evidence in court, there is provision for witness fees. And I would imagine that the Commission should have similar provisions that are applicable to it. I don't know what limits there are, but I would have imagined that they should be, their rate should be such that it should, as far as possible, place the person, the witness, in the position he or she would have been in if she had not been called to come and give evidence. But I think that probably at this stage there is nothing more one can say other than that that avenue should be explored. That might not fully cover your situation, but it might go to a certain point, is that right?
That is correct, Chair.
Yes, I think that must be explored. I can see no reason why there wouldn't be a similar provision applicable to the Commission, but the legal team can look into that and you can be in touch with them.
Thank you, Chair.
We look at the applicable law.
Yes, look at the applicable law. Yeah, thank you.
Thank you. Chair, the final matter is that Mr. Nxasana is booked on a flight at 7 o'clock, so if we may, because we're going to come back another day anyway,
Yes.
adjourn at the
At
normal
4.
time.
Yeah, no, that's fine.
Thank you.
So, one second, Mr. Pretorius. Can you ask them to also join the aircon, just slightly? Thank you.
Thank you, Chair. Mr. Nxasana, at page 11 of your statement, you deal with the circumstances giving rise to your ultimate suspension by the President. For the moment, we're not going to deal with the evidence that you intended leading concerning the circumstances which you say it would have explained or would explain the President's actions, because those are matters which implicate other parties.
Yes. But just for correction, I wasn't ultimately suspended, just for the record.
Yes. Yes, there was an intention
There was an intention
to
to
suspend, and that was the subject matter of litigation.
That is correct, Chair.
Yes, I'm sorry if I put it that way. You also deal with the steps that you took to ensure that in any process that occurred in relation to your employment, you attempted to ensure that you would receive a fair hearing.
That is correct, Chair.
You deal with the inquiry that was intended to be held under Advocate Nazir Kassim.
That is correct.
We won't go into that for the moment, simply because I'd like to keep the evidence in its proper sequence. You then deal with the situation at the NPA during your term of office, which has been the subject of comment by the courts and concerns the conduct of persons who are implicated by your statement.
That is correct, Chair.
I'm not going to test the fine distinctions between what are facts within your knowledge that haven't been canvassed in court and what evidence has been canvassed in court. That's perhaps too fine a distinction to draw at this stage. So what I'd like to do is just to place on record, as is common knowledge, that you ultimately entered into what has been termed a settlement agreement.
That is correct, Chair.
That settlement agreement involved payment to you of a sum of money.
That is correct, Chair.
That issue came before the courts. And what came before the courts were not only the terms of the settlement agreement, but the fact of the settlement agreement, the circumstances in which it took place, and its lawfulness.
That is correct, Chair.
That litigation, of which you were a part but not the principal applicant, finally found its way to the Constitutional Court.
That is so.
And in a judgment of the Constitutional Court, which is contained in the bundle at page 85, the Constitutional Court dealt with the evidence placed before it.
1 second, Mr. Pretorius. There is a judgment that was left behind, but maybe there might be no way of getting it. It's okay, let's look. Thank you. You may proceed.
The Constitutional Court dealt with the evidence that had been placed before it, dealt with the judgments of the courts below, and came to its own findings in relation to the issues before it, principally matters relevant to the National Prosecuting Authority and in particular relevant to the eventual ending of your term of office.
That is so, Chair.
And I'd like to go there directly, if I may, to deal with firstly some general comments made by the majority of the court under the hand of Madlanga J, Justice Madlanga. And if one can go to paragraph 6. The Constitutional Court in its majority there says, and that's at page, I'm sorry, Chair, that's at page 92 of the bundle, where the background is dealt with.
Thank you.
Paragraph 6 reads, "The events that are at the center of these proceedings are in the public domain. The judgment of the High Court notes that it was common cause before that court that since September 2007, the recent history at the NPA," and it quotes the judgment of the High Court, "has been one of paralyzing instability."
Yes.
That is the quote. That judgment gives detail of that history. If we may go then to paragraph 7, it reads, "In July 2014, within about only 9 months of his appointment, a process calculated to remove Mr. Nxasana from office commenced. That process would have been the substance of your evidence today,
That is correct.
in the main at least. The then President," the judgment continues, "Mr. Jacob Zuma, informed Mr. Nxasana of his intention to institute an inquiry into his fitness to hold office. This was followed by a notice that the former President was considering suspending Mr. Nxasana pending finalization of the inquiry. The former President said that suspension was necessary in order to maintain the integrity and good administration of the NPA. Your evidence would have dealt with that contention in some detail because you, in your evidence, would have today and will in the future give evidence regarding what you regard as the true reasons for what occurred.
That is correct.
The notice also specified that the inquiry sought to establish whether certain issues were consonant with the conscientiousness and integrity of an incumbent in the office of the National Director of Public Prosecutions as required by the NPA Act." We've referred to that section of the Constitution already, Mr. Nxasana.
Yes.
The issues were Mr. Nxasana's previous criminal conviction for violent conduct, allegedly unbecoming and divisive comments which had the effect of bringing the NPA into disrepute made by Mr. Nxasana and reported in the media, and alleged non-disclosure of facts and circumstances of prosecutions which Mr. Nxasana had faced previously. Now, in your evidence, you will go into some detail in regard to these issues, and in particular the lack of particularity that you alleged in court proceedings you had been subjected to.
That is so.
And in fact, reference is made to that in the latter part of paragraph 8 on page 94 of the bundle, where the Constitutional Court says, Mr. Nxasana approached the High Court seeking an order compelling former President Zuma to provide the required particularity and interdicting the former President from suspending him until he had furnished him with this particularity. That particularity, Mr. Nxasana, is that to which we've just referred.
That is correct, Chair.
The application was not that application was not pursued to finality. The former President changed tack. in late 2014, he proposed that the dispute between him and Mr. Nxasana be mediated. Mr. Nxasana acceded to this proposal. Is that correct?
That is correct.
And then paragraph 9, which is on page 94 of the exhibit, EE, reads, "It appears from a letter written on 10 December 2014 by attorneys acting for Mr. Nxasana that former President Zuma had engaged Mr. Nxasana to get him to agree to vacate office. In the letter, Mr. Nxasana made it plain that he did not want to vacate office as there was no basis for him to. He stated that he would, however, consider stepping down only if he was fully compensated for the remainder of the contract period." Is that a correct record of the facts as far as you're concerned? I'll give you an opportunity to expand on it in a moment.
Yes, that is a correct record.
At issue in the litigation, in part at least, was whether you had requested the former president to be allowed to vacate office, or whether you were compelled to vacate office against your will, but subject to certain conditions.
Chair,
If I haven't put it correctly, it's now your opportunity to place the issues in dispute before the chair.
okay, thank you. Chair, at no stage did I make a request to vacate the office to the president, to the former president, Mr. Jacob Zuma. And that letter of the 10th that is referred to here, I was also involved in drafting that letter, confirming the discussions that we had with the president in the company, and President and Mr. Hali, together with my legal representative. Therefore, the court found correctly that I did not make any request. I never made that request.
The position is summarized in paragraph 12 of the Constitutional Court judgment, and that appears at page 95 of Bundle EE, Exhibit EE. It reads, "It must be noted that right from the onset and throughout the entire negotiation process that culminated in the settlement agreement, Mr. Nxasana unequivocally stated that he did not wish to resign and that he considered himself to be fit for office. Instead, his preference was for former President Zuma's allegations that he was no longer fit for office to be tested in a formal inquiry as proposed by the former president." Is that the proposed Kasim inquiry?
That is correct, Chair.
The summary of the judgment continues, or the judgment continues rather, "Throughout he protested the existence of a factual or legal basis for him to vacate office. Also, he disavowed any invocation by him of section 12(8) of the NPA Act to voluntarily vacate office. It is so, of course, that he did indicate that he would resign only if he was paid the full salary for the remainder of his term of office." Does that fairly summarize the position as far as you are aware?
That is correct. It fairly summarizes the position.
Then there are some general comments, Chair, which I think it is appropriate to place before you, because the evidence that will be led by the legal team deals pertinently with these issues, and these comments of the Constitutional Court are instructive and very important for the work of the Commission, and if I may place them on record.
Yes, you may do so.
At paragraph 18, the Constitutional Court says, "The importance of the office of NDPP in the administration of justice is underscored and amplified by no less an instrument than the Constitution itself. Section 1794 of the Constitution requires that there be national legislation which guarantees the independence of the prosecuting authority." lower down the paragraph, it reads, Section 1794 provides that national legislation must ensure that the NPA exercises its functions without fear, favor, or prejudice. That legislation is the NPA Act. Predictably, Section 32(1)A of the NPA Act requires members of the prosecuting authority to carry out their duties without fear, favor, or prejudice, and subject only to the Constitution and the law. Paragraph 19 reads, this court has said of the NPA's independence, and it quotes, there is a constitutional guarantee of independence, and any legislation or executive action inconsistent therewith would be subject to constitutional control by the courts. The reason why this guarantee of independence exists is not far to seek. The NPA plays a pivotal role in the administration of criminal justice. With a malleable, corrupt, or dysfunctional prosecuting authority, many criminals, especially those holding positions of influence, will rarely, if ever, answer for their criminal deeds. Equally, functionaries within that prosecuting authority may, as CASAC submitted, be, quote, pressured into pursuing prosecutions to advance a political agenda. All this is antithetical to the rule of law, a founding value of the Republic. Also, malleability, corruption, and dysfunctionality are at odds with the constitutional injunction of prosecuting without fear, favor, or prejudice. They are thus at variance with the constitutional requirement of the independence of the NPA. It continues, at the center of any functioning constitutional democracy is a well-functioning criminal justice system. In Democratic Alliance, Yaqub ADCJ observed that the office of the NDPP, quote, is located at the core of delivering criminal justice, unquote. If you subvert the criminal justice system, you subvert the rule of law and constitutional democracy itself. Unsurprisingly, the NPA Act proscribes improper interference with the performance of prosecutorial duties. Section 32(1)B provides, subject to the Constitution and this Act, no organ of state and no member or employee of an organ of state, nor any other person, shall improperly interfere with, hinder, or obstruct the prosecuting authority or any member thereof in the exercise, carrying out, or performance of its, his, or her powers, duties, and functions. And then the court makes some further comments relevant to your evidence, Mr. Nxasana, and generally relevant to the evidence that will be led and the concerns raised by this commission. At paragraph 21, which is on page 98 of Exhibit EE, it reads, improper interference may take any number of forms. Without purporting to be exhaustive, it may come as downright intimidation. It may consist in improper promises or inducements. It may take the form of corruptly influencing the decision-making or functioning of the NPA. All these forms and others are proscribed by an act that gets its authority to guarantee prosecutorial independence directly from the Constitution. Paragraph 22 reads, another guarantee of the NDPP's independence is provision for security of tenure. In Section 12(1), the NPA Act provides that the NDPP shall hold office for a 10-year non-renewable term of office. It is now well established in terms of this court's jurisprudence that security of tenure is an integral feature of the constitutional requirement of independence. In Justice Alliance, and the reference is given to that case, this court held that, quote, international standards acknowledge that guaranteed tenure and conditions of service adequately secured by law are amongst the conditions necessary to secure and promote the independence of judges. These necessary conditions must, of course, be true of the independence of the NPA as well. In a unanimous judgment in McBride, Bosiello A.J. said that amongst the factors that are relevant to the independence of officers or institutions, which in terms of constitutional prescripts, must be independent are, and is a quote from the judgment, the method of appointment, the method of reporting, disciplinary proceedings, and the method of removal from office and security of tenure. And we here dealing, Mr. Nxasana, in your case with the removal of yourself from office and the circumstances in which that took place and the lawfulness of that set of events. There is a further comment relevant to the previous comment in paragraph 23, which reads, the NPA Act has two other salient features that help shield the NPA from improper interference, namely the non-renewability of the 10-year term of office of the NDPP and certain safeguards on the removal of the NDPP from office. And then the various methods that are provided for termination of the office of NDPP are dealt with. It goes on to say in paragraph 24 that the manner in which your office was vacated, Mr. Nxasana, was not constitutionally compliant, and you recorded in the judgment as having accepted that. Is that correct?
That is correct, yeah.
And then paragraph 25, certain salient comments are made concerning the conduct leading up to your vacation of office, and paragraph 25 reads, that is on page 100 of the judgment. The facts set out above point to one thing and one thing only. Former President Zuma was bent on getting rid of Mr. Nxasana by whatever means he could muster. His was an approach that kept on mutating. It was first a stick, then a carrot, a stick once more, and eventually a carrot. There was first the notification that Mr. Nxasana would be subjected to an inquiry with a view to establishing whether he was still a fit and proper person to hold office. Concomitantly, there was a threat of suspension pending finalization of the inquiry, albeit with full pay. This was followed by former President Zuma's proposal that there be mediation. When there was no progress on this, the inquiry was instituted. Whilst the inquiry was in its preliminary stages, the former president pursued a parallel process in which Mr. Nxasana was first offered, in a draft settlement agreement, 10 million rand. As indicated earlier, he did not accept it. What plainly evinces how desperate former President Zuma was to get rid of Mr. Nxasana is that this was followed by a draft settlement in which the amount was left blank. Mr. Nxasana was being told to pick whatever figure. Indeed, Mr. Hully said that he would, quote, await the final amount from Mr. Nxasana. And then the question is asked in paragraph 27. Instead of settling for so huge an amount, why did the former president not simply pursue the inquiry? Did he not believe that the evidence that had motivated him to come up with the idea of an inquiry was sufficiently cogent? If so, why did he not just abandon the inquiry and leave Mr. Nxasana in office? After all, he was exercising his powers as president and not involved in a personal dispute which he could settle as he pleased. It is difficult to comprehend why he would have settled on so huge an amount from public coffers to boot. Continues in paragraph 28, the inference is inescapable that he was effectively buying Mr. Nxasana out of office. In my book, conduct of that nature compromises the independence of the office of NDPP. It conduces to the removal of troublesome or otherwise unwanted NDPPs through buying them out of office by offering them obscenely huge amounts of money. Then, in addition to those comments, certain comments are made in regard to your own conduct in accepting the amount of the settlement. And I'll come to that in a moment, Mr. Nxasana, but as far as you know, is that a fair summary of the facts that were at least placed before, and I'm excluding any opinion now, that may have emerged from the judgment. I'm just relating the facts.
Yes, it's a fair a remark that is contained here.
I know that you are more empathic with the minority judgment,
Yes.
which we will come to in a moment and
Yeah.
explain the differences. But your evidence then not only deals with the termination of your office as NDPP, but the real reasons that you allege existed which caused your office to be ended.
That is correct, Chair.
And that evidence would implicate certain individuals,
Certain individuals, yes.
and it is to those individuals that notice will be given, and in relation to whom you will give evidence in due course.
That is so, Chair.
But as I understand that evidence, it is such that there is an explanation for the conduct which led to the termination of your services.
That is correct, Chair.
I must put before you the comments of Justice Madlanga in paragraph 85 of the judgment. Those appear on page 123 of the bundle, Chair. In the latter part of paragraph 85, Justice Madlanga says the following: effectively, although Mr. Nxasana strongly protested his fitness for office, he was saying he was willing to be bought out of office if the price was right. As much as I sympathize with him, I do not think that is the reaction expected of the holder of so high and important an office the holder of which, if he or she is truly independent, is required to display utmost fortitude and resilience, even allowing for human frailties, because Mr. Nxasana is human after all. I do not think the holder of the office of NDPP could not reasonably have been expected to do better. His conduct leads me to the conclusion that a just and equitable remedy is not to allow him to return to office. Having decided, as the Constitutional Court did, that the termination of your services was unlawful, the further question arose in relation to which the majority and the minority disagreed.
Yes.
And that was whether you should be allowed to return to office. In fairness, you should be entitled to comment now that that evidence is on record, or that judgment is on record.
Yes, Chair. Are you asking me to comment?
Yes,
on it?
if you wish to.
Yes, thanks.
It's an adverse comment, and therefore, in fairness, you should be allowed
Yes.
to put
Thanks.
your own
Thanks for that.
opinion before the court, before the judge, or before the chair.
Firstly, Chair, as things were going on and that have been going on after I left office, I felt that had this matter come before the Constitutional Court, after this commission was constituted, and after the other commission of inquiry had been constituted, I strongly believe that the majority in the Constitutional Court would have come to a different conclusion. That is my view.
That is in relation to whether you should be reinstated or not.
That is correct, Chair.
Okay.
Perhaps
Not in regard to the main issue, in regard to remedy. In other words.
to the remedy, Chair, I felt that the...
Okay, I'm sorry, I may be confusing you.
Yes.
I just want to make sure that I understand where you locate your comments. You have just said that you felt or feel that had the Constitutional Court considered that matter after this commission and after
The Mxolisi Commission.
the Mxolisi inquiry,
Inquiry.
they may have come to a different conclusion.
Yes,
So
that's my
I'm-
view.
I'm just asking whether the conclusion you are talking about is with regard to whether it should be reinstated or not, or are you talking about the main conclusion on the matter?
I believe that the conclusion would have been the same as the conclusion reached by the minority judgment, that I should be reinstated.
Okay.
If we have time, we'll get there in a moment. Just to place the judgment of the majority in proper context, its reasoning, at least in part, is in paragraph 87, which appears on page 124, bundle EE, exhibit EE, reads, "The narrative at the beginning of this judgment shows that for a few years there has been instability in the office of NDPP, and therefore in the leadership of the NPA. With the court challenge to Mr. Nxasana's vacation of office and to the appointment of Advocate Abrahams, that instability persists to this day. The second judgment, that's minority judgment, accepts correctly that it would be open to the President to initiate an inquiry into whether the manner in which Mr. Nxasana vacated office renders him unfit to hold office. The order proposed by the second judgment thus has the effect of prolonging the instability. The second judgment proposed that you should be allowed to return, or as a matter of law, that your contract should continue. In fact, that is the effect of the judgment.
Yes.
Relying on former president of the Labour Court reasoning that where a dismissal is invalid and unlawful, nothing needs to be done. The employment contract just continues. Zondo J.A., I think.
Well, there's never been a Zondo J.A. Yes,
President of the Labour Court,
Zondo J.P.
JP.
Okay, yes.
The order proposed by the second judgment thus has the effect of prolonging the instability. So it seems that part of the reasoning of the majority was that the instability by allowing you to return, and the majority felt it had a discretion in that regard, which should be exercised in favor of the conclusion that you should not be allowed to return. The concern was one of stability at the NPA. And then one of the further results of the judgment of the Constitutional Court is that the appointment of Advocate Abrahams was declared invalid, and the President was directed to appoint a replacement for Advocate Sean Abrahams.
Yes.
If I may then just briefly go to the order. You were ordered then to repay the amount received by yourself less tax. Is that correct?
That is correct, Chair.
And then in the minority judgment, after a long debate over the consequences of a declaration of invalidity in regard to termination of an employment contract, the conclusion is reached at paragraph 112 by the minority, which is at page 134 of the bundle, Chair, where Justice Jafta stated, "In the present matter, there is nothing exceptional or extraordinary that warrants the exercise of remedial power to prevent Mr. Nxasana from returning to office. His return will certainly not cause a constitutional crisis or a national crisis. On the contrary, his return would enable the President to follow the law if he wishes to remove him from office, and Parliament would play a vital part in that process. And more importantly, preventing Mr. Nxasana from returning to office without pronouncing on the validity of his employment contract would not only be unfair to him, but would also create considerable uncertainty on the party's rights and interest. this would be antithetical to the rule of law which promotes certainty. And in relation to a just and equitable order, the court found at paragraph 128 in the minority, page 140, as mentioned, allowing Mr. Nxasana to go back to his job would also meet the objects of the Constitution and the rule of law. If his involvement in the impugned settlement agreement brought his fitness to hold office into question, he may be removed in Section 12 of the NPA Act. For all these reasons, says the minority, I do not support the conclusion that Mr. Nxasana ought not to resume office following the setting aside of the invalid and unlawful termination of his appointment. That is, in summary, what the Constitutional Court found after all the evidence had been placed before it, had been considered by the lower courts, and was finally considered by it, and we all know the result. What remains is for your evidence to clarify the circumstances which led to steps being taken to remove you from office, and those will be the subject of the further evidence of Mr. Nxasana. Is this a convenient time, Chair?
Yes, it is subject to just mentioning that the last part that you talked about in regard to the judgment comes from the minority judgment.
Yes.
And what you said at the end might be misunderstood as if you're saying that's what the court said, but what you intended is to say some of the things you have said come from the majority judgment, and the last bit comes from the minority judgment.
Yes, the last quotes were all from the minority judgment.
Yes. Okay, yes, we can adjourn now. So, Mr. Nxasana will adjourn, and it's on the basis that you will be asked to come back, and the legal team and yourself liaise with them with regard to what witness fees or what fees may be payable when a witness has come to the commission and because of that is not able to work and earn income. For somebody who is self-employed, it's quite important. I'm hopeful that there is a provision that should take care of that. But you will be asked to come back.
Thank you, Chair. I will.
Yes, but other than that, thank you for availing yourself, and then arrangements will be made as to when you will come back, and the legal team of the Commission will make sure that implicated persons are given Rule 33 notices.
I might just add, Chair, that the Commissions Act under which we operate was passed at the time that the currency was still in pounds, so that may favor the
Yeah, so he might prefer that the remuneration be in the currency stipulated in the Commissions Act of 1947.
I think the Interpretation Act may have something to say about that, but we can examine it.
Yes. No, thank you very much once again. You are excused.
Thank you, Chair.
We adjourn. And tomorrow we'll start at, what time should we start?
9:30, it's the aviation
Yes.
stream of evidence, and I think I mentioned to you, Chair, the start time of 9:30
Yeah, we'll
throughout
start.
the aviation.
We'll start at
stream.
9:30 tomorrow morning. We adjourn.